So I'd like to thank Professor Sima and the staff of the CEVRO Institut for a tremendous job they've done in hosting this conference, and Professor Romello and Marciano for organizing this event.
Kip, lift the microphone up just a little bit. You're taller.
Oh, okay. Anyway, thanks to everybody for organizing the event. This paper is with Joni Hersch, who's in the first row, and hopefully she won't disavow much of what I say here today. I'm going to be talking about Professor Calabresi's article on the insurance role of tort liability. Let's see if this works. How do I advance? Do I advance? I can do. It's going to be a long time. Go ahead. Oh, yeah. So, now I'm in business. So the article focuses on insurance as a key function of tort liability. He doesn't deny that deterrence matters, but he says he's going to set deterrence aside and focus on the insurance role of tort liability. And I'm going to stay true to the insurance role of tort liability as part of this talk and see how well tort liability does as an insurance mechanism. So the main focus is going to be on how does understanding the insurance function assist in our understanding of the role of tort law. So once we start thinking of tort law as in its ability to provide insurance, does thinking of tort as an insurance mechanism help us understand what tort can do and what it can't do? So does understanding the importance of insurance assist in our understanding of the capabilities of tort law? And I'm going to suggest that in some cases tort law works great as an insurance mechanism. In some cases it works less great as an insurance mechanism. And where it works less great, it probably is less successful overall. And then it's been a long time since he wrote that article. It's been over 50 years. So has the world changed in the past 50 years? In particular, has the structure of tort law changed? And how does that affect the insurance function that tort law can successfully serve? So let me just review his insurance analysis. First, insurance remains a key objective of tort law. It's central to an assessment of what the appropriate damages payments should be. And the approach I'm going to be taking here today is when you think about the correct damages payment that you want in a tort context, you might want to think of the thought experiment. If you could structure an actuarially fair insurance policy on your behalf, what kind of benefit would you like to provide to yourself after different kinds of injuries? So that might be different than how you'd answer the question after you've been injured. But before you've been injured, if you could design a perfect insurance plan, what would this plan look like? The thinking about tort as an insurance mechanism was central to the development of the strict liability doctrine in the United States. We can make firms strictly liable for products because they simply can serve an insurance function and transfer the cost to consumers through higher prices was the general storyline. And the risk utility test for products where firms should balance the risk and utility of the products, of potentially dangerous products, where one of the considerations is to what extent can the firm provide insurance to the consumer who might be injured by the product. Calabresi developed the insurance analogy model for torts. And what is the insurance model? Well, what the tort law does, just like insurance, it transfers funds to the injured party. So if you're injured, you get money, just like insurance. The implicit premium is something you pay, but in terms of a product price. So whereas in the case of insurance, you pay for an explicit insurance premium, in the case of product liability, if the firm is in effect providing this insurance for the harm caused by the product, you pay for that insurance through a higher product price. The good news is that the losses are spread across all consumers. So if there's, let's say, only one consumer who's injured every year and lots of people who buy the product, that loss is spread across all the potential purchasers, just like in the case of insurance. Not everybody's house burns down each year. And this would be attractive to people if you're risk averse. Most of us are risk averse. We're not willing to take unfair gambles, so that this is a good thing. And he presents workers' compensation as an ideal model. And I would say it's not only ideal, it's an idealized model, since workers' compensation in the United States works great. And I'll be talking about how well it works and comparing it to tort law generally as I go through this. Let me go through the insurance basics. If you have a chance 1 over n of a loss D, a risk-averse consumer would prefer an insurance premium of D over n to a risk 1 over n of some loss D. So this is the same principle that gets you to buy insurance to begin with. And if firms can deliver this through product liability, that would be a good thing. The effect of insurance through tort liability will be the higher product price. And if there's competition in the market, the product price, the extra product price, will be how much it raises the marginal cost of the product. It raises the marginal cost of the product by D over N, so that the expected cost of the insurance is how much the price is going to go up. The key for this to work, just like your insurance company, the key for your private insurance to work is that you pay the premium before your house burns down. Okay? And the same thing is true here. The key for this market context to work is that the defendant has to be able to collect the premium in advance of the accident. So it must be able to anticipate what's going to be happening and what they'll have to pay out after the fact. Well, here's the workers' compensation example, which I've spent a lot of time working on. When I first started working on workers' compensation, it was called workmen's compensation. But now they've decided to go with a gender neutral named workers' compensation. And in the United States, these programs are administered by the states. So it's not a federal program, but every state has a workers' compensation program, and employers are required to provide workers' compensation. How do they pay for workers' compensation? The employer pays for it. So the employer has to pay a premium, a workers' compensation premium, and if you're injured at work, tort liability is gone. You're not permitted to sue your employer. So if after teaching I fall down the steps, I can't sue the university, but I can collect workers' compensation benefits. Even if I was negligent and I was carrying too many books down the stairs, they'll still compensate me. It's a no-fault system. So any job-related injury, I get compensated for. So it's a no-fault. It's also an administrative compensation system. So you don't go to court. If I'm injured, I have a particular type of injury. There's a series of scheduled payments, and typically I would get paid 2/3 of my wage rate, subject to a wage cap that's the typical wage for average U.S. manufacturing worker. So it would not be that good a deal for me financially. Who pays? As Professor Calabresi pointed out in his article, the nominal division is irrelevant. Yes, who we label as paying for it doesn't matter. So it doesn't matter if we say the worker has to pay for it or the firm has to pay for it. It's all going to work itself out. So the question is, how does it work out? Well, there's a lot of storylines in the literature. The whole literature on product liability and strict liability is that all these costs of tort liability insurance will be transferred in some way through a market process, but nobody actually documented that this process actually happens. So I did this for workers' compensation about 20 years ago, looking at worker wages. And what happens is that if you're provided workers' compensation on a risky job, workers will perceive that as a positive aspect of the job. A risky job's not a good thing, but getting compensated for the risk is a good thing. And workers are willing to pay for that through a wage offset. As it turns out, the wage offset that workers incur for workers' compensation benefits in the United States exceeds the cost of the workers' compensation. So the empirical offset is that the wage offset exceeds the premiums. So there's empirical support for the insurance analogy, and it's not surprising that the wage offset exceeds the premiums. When you buy insurance, when you're risk averse, you're willing to buy insurance even though it's not actuarially fair. And if you buy private insurance, if you spend, for every dollar you spend on premiums, you don't get back $1 from your insurance company. So it's the same thing that happens there. There's an added bonus that we might as well throw in here, since even though we're talking about insurance, deterrence matters as well. So that job fatalities, I've estimated in the United States, if we didn't have workers' compensation and the financial incentives provided by workers' compensation, we'd have roughly a third more people killed on the job every year than we do now. So the financial incentives of tort liability really do matter, and that's one added bonus in addition to compensation. So what are the 5 potential pitfalls of torts insurance? So this is going to structure what we talk about the rest of the time. First, just like insurance, expected losses must be predictable to charge meaningful premiums. Second, tort liability litigation costs can be high. So as an insurance program goes, it's not this effortless, costless mechanism. Third, catastrophic losses may exceed insurers' resources. It's not a simple matter for firms to bear all these costs. Fourth, correlated risks undermine risk pooling and risk spreading. So the same type of problem that happens in the United States for like earthquake insurance. Private insurers can't go out and start writing earthquake insurance in California, because if one house goes, they're all going to go. And same thing with flood insurance for people with beachfront homes in the United States. We have federally subsidized flood insurance run by the federal government. There's a temporal mismatch between insurance losses and payments, and that can create problems that I'll discuss. So first, punitive damages is over insurance. So if damages consisted simply of financial losses, then we wouldn't have to worry about providing too much insurance. One way in which you'll have too much insurance if there's an award of punitive damages. Now, punitive damages are not as common in Europe as they are in the United States. They're not rampant in the United States, but we have often substantial punitive damages. So this would be a penalty above and beyond the economic loss and above and beyond any pain and suffering. So we will assume compensatory damages make the person whole or make the victim whole, and it's easy to fully compensate your financial losses, but punitive damages provide an additional punishment, and economists don't have much of a good theory as to what we should do about punishment. We know a lot about deterrence, and we know a lot about compensation, but whether we should punish people and how much of a penalty we should punish people is something there's not a very well-developed economic analysis. Most economics, at least Bentham through Becker, through Cooter, through Polinsky and Chevelle, would probably set punitive damages equal to 0 unless there's some probability of not detecting the harm. Punitive damages can be large. In an early paper Joni Hersch and I wrote, we identified awards of $100 million or more, and thus far in the United States there have been over 100 blockbuster punitive damages awards of $100 million or more, but they don't end up all getting paid out. Typically judges reduce these awards. There's one case, a single cigarette smoker case in Los Angeles, California, where the jury awarded $28 billion. The judge figured the jury didn't know the difference between $28 billion and $28 million, so he immediately reduced the punitive damages award to $28 million, which was still a lot of money, but it was a whole lot less than $28 billion. But anyway, judges have done a lot to rein in punitive damages in the United States, as well as and the Supreme Court in the United States has had a number of rulings that have really dramatically scaled back punitive damages. So I'm going to talk instead about pain and suffering. And this is interesting because if you look at the article, his original article, it doesn't really focus on the damages components. So it's really pretty much a discussion in terms of financial loss. But a major component of damages is pain and suffering, and he made some comments about that yesterday, and I'm going to follow up on that today. How would a jury set compensation for pain and suffering? So if you've experienced an injury, the jury can award compensation not only for your financial loss, but whatever pain and suffering you've incurred. So let's say your injury is that you were hit by a trolley leaving the conference and you're now a quadriplegic. So, or let's say you're trying to figure out how much of an award should be awarded to somebody who's now a quadriplegic. So you get these jury instructions. I'm going to read, these are sample and jury instructions. We'll assume it's a woman who's hit. You're instructed that the plaintiff is entitled to be fairly and adequately compensated for all physical pain, mental anguish, discomfort, inconvenience, and distress that you find she has endured from the time of injury until today, and that the plaintiff is also entitled to be fairly and adequately compensated for all physically pain, mental anguish, discomfort, inconvenience, and distress you find she will endure in the future as a result of her injuries. Well, you can't exactly run with that in terms of putting a number on it. So saying somebody should be fairly compensated basically begs the question of what the compensation should be. I like to think of this in terms of what's the optimal insurance amount. So before you were injured, if you could structure an insurance program to provide compensation to you after you were injured, how much compensation would you want after the injury? So the uncertain guidance promotes unpredictable tort insurance. There's variability. Generally, the optimal insurance will be less than the make-whole amount if the injury lowers the marginal utility of income, as severe injuries do. So let me say a few words about pain and suffering. So yesterday, Guido Calabresi said, I thought that it would be irrational for him to want extra compensation because of his emotional attachment to his luggage that's damaged. Now, I wouldn't call that irrational. I'd call that strange as a preference, but not irrational. So I'll take a case of my similar strange preferences. So I have recently got a midlife crisis sports car. And I was rear-ended last week, and it damaged the rear bumper. And as we speak now, they're putting on a new bumper. They're going to paint it and try and make it look as good as new. But it really won't be as good as new. So to truly make me whole, I would want the insurance company to buy me a brand new car, okay? Because I really have this emotional attachment to this new car. And it's not going to be this new perfect car anymore that was made in the BMW M factory. No, it's going to have this bumper that was spray painted in Nashville, Tennessee on it. So I'm not being made whole, but they don't really, there's no way really to convincingly or convey to the insurer that, yes, I do need a new car, not just a new bumper. And that's the problem with this emotional attachment. If people have emotional attachments to things, there's no incentive for people to reveal their preferences honestly and get compensated the appropriate insurance amount. There's a case that I read about it at the lunch break. I pulled out my iPad, and there's an award for a quadriplegic in the Second Circuit that was upheld for $48 million. Now, I've been working with the Czech crowns, and I figured that sounds to me like 1 billion Czech crowns if I'm doing the math correct. So that's a lot of money, whether it's Czech crowns or dollars. Now, is that too much? Now, I don't know about the composition of the award, but you figure if it's $48 million, a third of that off the top is going to go to the attorneys. So I think that, so $16 million is going to the attorneys. A few million bucks is going to go for the present value of lost earnings. And the rest, if it goes to medical care for being a quadriplegic, if you're getting good medical care, great 24-hour medical care is really, really expensive in the United States. So if it's mostly medical care, that would be great. But if it's pain and suffering, this is money the person really can't enjoy spending. He can't take trips to Prague after this. He's not going to consume it. So in that situation, the award might be providing excessive insurance. So the correct amount would be to compensate for the economic loss, compensate for the medical malpractice, for the medical expenses, give people enough money to cover their attorney fees. But if their marginal utility of money has gone down, don't throw a lot of money at them for pain and suffering. Now, I'm not just sort of making up this thought experiment. I've done a series of studies for the U.S. Environmental Protection Agency where we actually estimate individual utility functions. How injuries affect your utility function depends on the character of the injury. So severe injuries such as disabling job injuries, multiple sclerosis, these sorts of things will lower your marginal utility of income. So that it will not be optimal for you to have the make-whole insurance amount. However, minor injuries, temporary hand burns, irritation of various kinds, for those sorts of injuries, money is an effective substitute. You can still enjoy spending money, and for those injuries, you would want to be made whole after the fact. And I'd still also want my new car. Anyway, so the insurance model of tort illuminates the limitations of money in addressing the loss. Empirical evidence on pain and suffering. Well, it can be really big. So Joni Hersch and I have done some work on medical malpractice and the non-economic damages share. And in the United States, for fatalities, it's anywhere from 2/3 to 3/4 of the award is for pain and suffering, or non-economic damages. For non-fatal injuries, 64% to 84%, depending on the age group. So the non-economic damages can be a very, very large player in the whole scheme of things. Loss of enjoyment in life. Not every place in the United States has an additional provision for loss of enjoyment of life, but some states do. Okay, so if somebody's killed, if you're killed by the trolley, crossing the street, then your survivors could sue and obtain damages for your loss of enjoyment of life. Now, from the standpoint of optimal insurance, you don't really want to bequest equal to enough money to make you whole. How much money do you have to anticipate that your heirs get in order for you to be indifferent to being killed or not killed? For me, there's not enough money that can make that's sort of a good deal from my vantage point. The number that's frequently used here would be the value of statistical life. And these are the numbers I've developed for U.S. government agencies. And my current number is around $9 million. So this is the value that's appropriate for preventing an expected death. And people such as Eric Posner and K.F. Sunstein have advocated that compensatory damages for wrongful death be the standard compensatory damages amount plus this value of statistical life number. So in effect, they advocate double counting as well as compensating people for this, what we might call the prevention or deterrence value of for fatality risks. In a separate paper, Joni Hersch and I have argued that the $9 million number does have a place to play, but mostly from the standpoint of deterrence. So if you care about deterrence or structuring an optimal incentive system, that's when you'd want to use that number, not as a routine compensation measure, and certainly not on top of compensatory damages. So the government agency used the value of statistical life for prevention of fatalities. No government agency in the United States has ever used it for compensation. In fact, they've explicitly opposed it in cases where the Federal Aviation Administration is implicated in airplane crashes, and plaintiffs try and get this amount for each airplane crash victim. Similar insurance concerns arise for environmental harms and other irreplaceable losses. We want to give people money when money can replace the loss, but if money can't replace the loss, as with my car or Judge Calabresi's lost luggage that he had an emotional attachment to, then we don't have to give them extra amount for that. The insurance model helps us understand the effective range of scope of tort liability. So here's some problems with product liability. Correlated risks. In design defect cases and warnings cases, it's not just an occasional random manufacturing defect. If one product goes, the whole product line often goes. So everything's bad. And if everything goes, it's like all the houses being burned down at the same time. That would be causing a big problem for your insurance company. So correlated risks undermine the risk pooling insurance function. If you can't pool uncorrelated risks, you don't have a good working your insurance plan simply can't work. So isolated manufacturing defects work. In that storyline, which was certainly the correct storyline back in 1961, that was how the world worked in terms of tort liability. But design defect claims have been on the rise since then, as have product warning claims, and these tend to affect an entire product line. Sometimes you can run a viable insurance product system with that, sometimes you can't. Examples of design defect cases, the copper 7 intrauterine device, the Dalkin shield, Firestone tires, which were very bad, and Toyota recently had an unintended acceleration case, but I think Toyota will be able to pay for all these costs. But correlated risk generally potentially can push the limits of tort as a smoothly functioning insurance effort, but still, even if a tort can't work as a great insurance effort, it still may have a viable role to play for deterrence. So I'm not saying we should abolish tort liability, but don't necessarily assume that insurance is sort of this effortless, costless activity. Latency period. So if you can't charge the premium up front before you pay the damages or know what the damages are going to be, the insurance plan's not going to work. And that's the problem with latency periods for illnesses. So you have a product, whether it's illnesses or birth defects or cancer, if that happens long after you've sold the product and you don't know what the liability rules are going to be down the road when you have to pay out, then you can't run the insurance operation in a viable manner. So tort risks must be known when the product is sold in order to charge the insurance premium. Producers can't charge tort costs retroactively. Some producers actually have tried to do this, and I'll point that out in a second. If you have a long latency period, it breaks the loss premium linkage for insurance generally. And, for example, insurance companies have caught on to this. In the United States, nobody really wants to write environmental risk insurance because environmental risks often have a very long tail so that it may be years or decades before you know what the harm was, and it's very hard to predict what that is, so insurance companies have basically tried to exit most of that market. Examples are DES had fertility effects on the children of mothers who took DES. Smoking risks occur with, the lung cancer risks occur with a latency period of a couple of decades. Evolving scientific evidence. We now know more about lots of risks than we did before. Well, can you recoup costs after the fact? Well, 2 U.S. airplane companies tried to do this. So when airplane crash tort liability cost escalated, they say, well, let's try and charge an extra $100,000 a plane to try and recoup our past, basically the retrospective liability from the planes we sold in the past. But they're undercut by cheap Taiwanese imports that didn't have this old tort liability cost that they're trying to pay off. So the way to look at tort liability costs is that they're fixed costs. You can't sort of charge them to the future consumers. You can only charge the expected costs associated with the current product to future consumers. You can't lay off on future consumers the costs associated with products you sold in the past. Mass toxic torts. The 3 key words here: mass, large numbers, toxic, usually a latency period for things like cancer, torts, personal injury cases, often injury and death, and there's often a 20-year latency period for cancer. You have large risk exposures, so over that entire 20-year latency period, if you don't know what you're doing and you're selling a product, year after year after year, you're exposing people to this risk. So in 20 years, when the risk becomes apparent, wham, you're going to be facing this whole backlog of cases that are going to hit you for the next 20 years. So the claimants for mass toxic torts, one tally, not updated. Dalkin Shield, 210,000 claimants. Manville asbestos, 190,000. Other asbestos, 150,000. So we're talking about a whole lot of people. So this is not like the random manufacturing defect that's easy to insure. At one point in the 1980s, 60% of all the cases in the federal courts in the United States, all personal injury cases, were asbestos related. So asbestos was, in fact, a big deal. Transactions costs. So how cheap is it to run insurance through the tort liability system? Well, workers' compensation is great. 80% net payout rate is an insurance operation. So for every dollar they pay in premiums, 80 cents gets paid back to workers. Fantastic. For workers' compensation, you have an administrative system. In the case of tort liability, it's not. It's not as administratively simple. You don't have administratively scheduled payment levels. So, and tort liability has a broader scope. workers' compensation in the United States does not pay anything for pain and suffering. All they do is pay you for economic loss, whereas tort liability pays you for economic loss, pain and suffering, and so on. Well, here's some costs from an earlier paper Joni Hersch and I did on the litigation costs associated with different kinds of tort liability. So for every dollar of net payment, what amount is devoted to legal expenses? This does not include cost of operating the court system. It's just the cost of the plaintiff's attorneys and the defense attorneys. For general liability, it's 82 cents for all claims. Litigated claims, it's 89 cents. Auto liability is the most efficient of these. 64 cents of legal expenses for every dollar. On average, it's 75 cents, and for cases that actually go to court, it's 83 cents on the dollar. So you can run an insurance system through the courts, but you keep in mind it's not cheap to do so because you have lawyers are not cheap. They eat up a lot of money in terms of both plaintiff and defendant litigation costs. Okay, so has the scale of liability changed dramatically since Judge Calabresi's article? Has it changed so much that our article is no longer pertinent to the world today? We have mass toxic torts, warnings cases, design defect cases. Is this a different world we live in? Well, to preview the result, no. I think the world is not that much different, but here we go. There's been an explosion of tort costs in nominal dollars. So the nominal dollar amount has gone way, way up. But much of the increase is due to inflation. And most of the inflation-adjusted rise was in the 1980s, when in the United States we had inflation in excess of 10% a year. But the inflation-adjusted liability costs have gone up. So for general liability, it's gone up from 7 billion, to 46.8. Workers' compensation, 10 billion to 31 billion. It peaked back there in the 1990s, went down since when a number of states enacted limits on workers' comp. But you can still see liability costs have gone up, maybe by a factor of 5 or 6 or 3, depending on which line you look at. Is that crazy? Well, the economy is bigger too. So rising costs were muted by tort reforms and cost controls, but the scale of the economy is almost 5 times greater than it was then. So you'd expect the cost to go up, even if they're just keeping pace with the scale of the economy. So the world we live in is not starkly different than the world of Judge Calabresi's original article in terms of the share of tort costs in the United States economy. So that total share, given how big the economy is today, is not dramatically different than it was when he wrote his article. So the role of tort compensation is not very different than it was back then. So the nature of tort law has changed in many ways, but not a greater overall cost. So let's go to the summary. Insurance remains the linchpin of economic theories of tort law. So I think that one thing this article did is he put insurance on the map. You can think of tort liability as serving a vital insurance function. I think that's great. I think running with that thought experiment of tort liability as insurance helps you understand enormous amounts of things about how tort liability functions and what its implications should be and how it should be structured. Tort law is most successful in ensuring financial harms from isolated risks with immediate consequences, such as auto accidents. The same is true of insurance generally. Private insurance efforts work best when you're paying off financial harms, not trying to figure out my emotional attachment to my car, from isolated risks so that not everybody's house burns down at the same time, and immediate consequences so you don't worry about a latency period of 2 decades before the cancer cases develop. The insurance lines that are more volatile for private insurers also tend to be more volatile from the standpoint of tort liability. So the same kinds of things that give private insurers trouble, like insuring environmental risks, also tend to be more volatile and more unpredictable for tort liability as well. So the punchline is that insurance is most feasible for predictable financial losses that you can price beforehand so that you can charge that implicit premium beforehand, and which are independent risks, not correlated risks. So, final point, conceptualizing the role of tort law using the insurance model, which is what he established in his article, continues to provide insight into the strengths and limitations of tort law.
May I? Well, this is a wonderful paper about which I'd have much too much to talk about. Let me begin by saying, by going back to Holmes in the common law, in which he asked whether spreading insurance should be a reason for liability. And he said no, because you can get insurance much more cheaply through the government or self-insure. And what I always say about that is he did that, but he separated that from the other goals of tort law. Because if the government covered all the insurance, there would be no deterrence function. And then we would have to do deterrence by hanging, drawing, and quartering, that is, by direct governmental action. And as to self-insurance, that would depend on whether the self-insurer were the better decision maker, in a way, in terms of deterrence, or the other side. So that when you come to some of these emotional damages, when I proposed a system of automobile accident reform for Hawaii, only for Hawaii because you don't drive from Hawaii to other places, I put pain and suffering as a first-party insurance notion, because I thought that as to many of these things, the victim was the one who could gauge best what that was, rather than the injurer. Okay. Now, one of the problems that Kip raises is the problem of knowing the risks ahead of time when the risks change so much. And there's no doubt that's a very serious problem, because in insurance, we do want to know the risk ahead of time. The question is, compared to what? That is, if a comparison is to private insurance, even with first-party insurance, you have the same problem. That is, either the person is not covered, or the insurance company is covering this unknown long-latency risk. Think about if people had been insured against asbestos as a private insurance thing. Insurance companies would all have gone broke. So the question is, do we prefer to have entrepreneurs do this, manufacturers, or do we prefer to have insurance companies? Given that insurance companies are risk-averse and maybe manufacturers are not. Now, maybe we don't prefer either, and we have to say for some of these, the government ought to be there. And I think that may be fair, realizing that that removes the deterrence effect. But it isn't enough, I think, to do what Kip does and says, these are real problems with having manufacturers do it, unless you look at the alternative in terms of insurance companies, because the problem is that these risks come out. Now, as to the high cost of torts, and therefore the high cost of insurance through torts, again, one has to say, does torts accomplish relatively cheaply some other things like deterrence and so on? And if it does, then the added cost of insurance may not be so great. Now, I happen to think that you can do all of the deterrence functions in tort-like ways, like New Zealand or some first-party systems, and do the insurance much more cheaply. So I don't think that torts is the best way of doing it. But if one doesn't agree with that, one has to at least take into account that it is doing some of these other things. My own feeling is that one of the highest costs of torts is, which is the major part of pain and suffering damages is the cost of lawyers for the way we determine liability, and we determine, because that's what contingent fees are, and that's what pain and suffering are. Pain and suffering is a form of mutual insurance on the part of victims to pay lawyers' fees. That's what it really is. Now, if we look at it that way, is that a good way of doing it or not? I think not, but you can't look at pain and suffering without looking at it from that point of view. In one other issue about that, about how much we're paying out, and whether this is just higher damages because of inflation or higher damages because of other things, I think one has to take into account that safety, like the environment, are superior goods in economic terms, and that the richer the society is, the more of it it wants. That's why developing countries tend to have relatively low damages. Superior goods, inferior goods. Superior goods are those that as people get richer, they buy more of. Inferior goods are those which, as people get poorer, they buy more of. Potatoes is the typical inferior goods. Then economists go crazy and say spaghetti is an inferior good, and that shows that everything is wrong, because spaghetti by definition is a superior good. But leave that aside, there are goods of that sort, and life and safety and the environment are bad. So it shouldn't be surprising that what we actually give for safety, pay for safety, is now more than just inflation, and in looking at both workers' comp and the other. But in the end, I think if you look at torts as a system of insurance, if insurance is the only thing we want, then it's miserable. And workers' compensation would be miserable, because workers' compensation pays 80%, but Social Security pays 99%. So there are far more efficient ways of doing insurance if insurance and spreading is the only thing we want. The question is, what is the best way of doing insurance if there are other things we want too? And then a system of liability with payments up to a certain amount and some first-party judgments with respect to pain and suffering may well be the best one. The existing tort system, which I said at least by the time of a cost of accidents, is not the best way of doing that. It's a lousy way of doing that. But I'm not sure that insurance in a system which also does deterrence, if it is done right, isn't better than one that tries to separate it out, because the alternative of putting some of these risks on private insurance companies is a disaster. Now, there are also some real mistakes that were made. When Chief Justice Rehnquist said that the Federal Torts Claims Act does not give rise to strict liability, and it was a reading of the act, and you could read it either way, did a disastrous thing with respect to asbestos. Because these were all claims that where the government was at least as much involved, more involved than any company, and here the risk was exactly a risk which one could, for both deterrence and insurance purposes, put on the government. Instead, we put it in a way that was disastrous for private companies for no good reason. Now, there were technical reasons why he did that. That's a mistake in torts, and we make mistakes either way. I don't want to get into punitive damages. I think that it's too punitive damages as overcompensation is true some of the time. There's a whole business of Sharkey and multiplier effects and other things, but punitive damages do too many different things. But in the end, a wonderful analysis, but let's always consider the alternatives, including what would happen for some of these unexpected, long latency things if they were put on private insurance companies, and whether given that, we should try to figure out some different way of handling these, either from the tort system or individual private insurance.
These are fantastic comments. With respect to, let me just say something about asbestos, since that's a topic I've struggled with as well. In the United States, most of the asbestos cases arose from shipyard workers exposed during World War II. The companies, the defendants in these cases, like Fiberboard, were simply following the contracts specified by the United States Navy regarding what they should be installing in these ships. So, it's hard, and from their standpoint, I don't see much of an incentive effect. They're just sort of following the government's mandate in terms of what to do. When I looked at this, I originally proposed that there be social insurance for, so that the government take over a social insurance system for compensation for asbestos victims. And then when the U.S. Congress started to explore these options, I was retained as a consultant to the U.S. Office of Management and Budget to figure out what it would cost to compensate all the asbestos victims. And the trouble is that not everybody who has an asbestos victim has a sign on them that says, I got my lung cancer from asbestos. So mesothelioma is a signature disease, but lung cancer generally is not. So you end up compensating about 10 times as many people who are not asbestos victims. And once you go down that road, why aren't we compensating everybody in the United States who has lung cancer and not just asbestos victims? And this gets to be really, really expensive. So I worked on that topic, then I gave up. But I think the idea of sticking to tort liability in situations when you can provide meaningful incentives is a good idea. So.
Okay, please. If I may, before you, just about asbestos that I find very interesting, as I know, I totally agree that there was a flaw both of the public system and the private system. But as far as I know, at the beginning of the 20th centuries, insurance companies were not any longer willing to insure workers in asbestos factories. So that was possibly another reason for having the tort system working.
Microphone.
So you said that people won't buy insurance for immaterial losses because the marginal utility of wealth does not increase after such losses. And this is easy to understand in the extreme case of non-fatal accidents. And then you mentioned the value of statistical life, kind of what Posner-Sunstein was supporting. And you said that this is done for deterrence reasons mostly, because after all, when a person has died, so on and so forth. But you also mentioned that for some personal injuries, it makes sense to compensate, because after all, the person would be able to use this amount of money to do alternative things. So I was wondering, what would be your response to the idea that for non-fatal personal injuries, to the idea that even though people won't insure themselves, they are still willing to spend some resources in order to avoid the probability of an accident occurring, which would be correct then from a deterrence point of view, because the injurer would be internalizing the cost the victim would be willing to spend, and the victim would not be over-insured against his will, which is essentially what Mark Geistveld was suggesting in a paper from 1995.
Sure. This is a real trick with compensation for tort liability, or let's call it a product liability case. The optimal deterrence amount is going to be pretty high. The optimal insurance amount may be a whole lot less if it's a situation involving disabling injury where you can't enjoy spending the money. There's a trade-off between how much money you want to get compensation, realizing that the extra compensation does provide a deterrence role, so that if the deterrence role is effective, then you're going to want to have more emphasis on deterrence role, making the company pay a lot more damages doesn't really alter their safety incentives, then you're going to care more about the insurance role. But yeah, the real problem is you can't do both perfectly in this situation. You can get around it with having government regulation or government penalties to get you up to the optimal or efficient level of product safety. So I still like the idea of having a lot of social institutions, not just the courts in charge of everything, but having product safety regulations, also trying to establish efficient incentives for safety.
I guess I am much more skeptical of regulation. I am much more libertarian than Kip in that respect. No, I think there are real problems with torts in doing this, even with a reformed tort system of a sort that one could have. And a reformed tort system would be one that would cut out an awful lot of the costs of lawyers. I know that all too well because when I proposed this system for Hawaii, and it was one in which people could insure themselves for pain and suffering beyond a certain minimum amount, which was the proper deterrent effect, I thought, but they could insure themselves for more because they were the best gaugers of that. And that could be done in a way which was quite easy to do as multiples of medical expenses and so on. And this was loved by the governor, who was Democrats and Republicans, they all loved it. And then the trial lawyers bought half-time during the Super Bowl to defeat it, only locally, but to defeat it, because what it did was cut out a huge number of transaction costs, which weren't really necessary. And it was apropos of that, by the way, that I said the thing about self-indulgence, because I had talked about the distributional effects to the plaintiff's lawyers as being obviously wrong. I still think they were wrong, but I wasn't saying that as a scholar, and so I was just, I had no scholarly reason. I just thought that they shouldn't get the money. And I thought that was a little bit self-indulgent, although I still will politically hold to that.
The question I have, there seems to be, if I understood you right, there seems to be a suggestion, at least, that the amount of ex post compensation should correspond to the amount of ex ante insurance somebody would purchase. And if that's right, I have a question about it that also goes to the statistical life question. Because ex ante, I don't think the insured has a very good idea of what the pain and suffering would be like, for example. And you have the same problem in the statistical life methodology, where the person doesn't know the odds of them dying when they accept the job. Really, they don't have that kind of information. And so I guess the question is, if that's right, and maybe I have some of this wrong, don't you need to have perfect information in order to have some suspicion this might be optimal? And isn't there no reason to think that individual choices would be optimal when the information is really bad?
Well, in terms of being able to anticipate what it's like, the studies we've done, we've tried to provide people with information about the symptoms of the disease. In the case of chronic bronchitis, show them that you're going around with oxygen tanks. So we've done different health outcomes. So I think if you ask the typical consumer, they may not be able to think ahead of time. But the thought experiment I'm running, or at least I ran, were actual field studies where we gave people the information about the symptoms associated with the disease. And we compared, for example, how did people who have chronic bronchitis for real, how are their preferences compared with those who we told, you might get chronic bronchitis that have these symptoms, And one of the interesting results we found was for MS, which is that for MS, the people who were healthy people, we told the symptoms of multiple sclerosis, were much more willing to risk a life or death cure than the people who actually had MS. So if you actually experienced the illness, they thought life was a whole lot worth living, a lot more than people who were trying to anticipate what it would do to their lives. So I think there's always it's difficult to anticipate, even from afar, how your preference is going to change after disabling injury. Usually you don't want more money, like if you're a quadriplegic, if they really pull out the stops and give you the very best medical care, you don't need additional money for consumption because you can't use it. So in situations like that, or after you're dead, you can't use it. In situations like that, I think paying people $9 million after they're dead, unless it's for deterrence purposes, would be excessive compensation, because it's not the amount of insurance you'd want to buy for your survivors after your death. I mean, generally, if you can compensate them for the present value of your lost earnings, that's the type of insurance people would purchase. The fact that you're not around to enjoy the extra 20 or 30 years of life expectancy is not something that you have now gone out and bought insurance for, and I don't think the courts should provide it either.
I don't know about the pain and suffering and whether people do get something even when they have no capacity to do anything. I think that's very hard. I've always had this problem, and I'm not sure that in what I've read of yours completely solves it, with the value of life. If I say to somebody, how much must I pay you for taking one risk in 1,000 of dying, that person will give me a figure which is actually too high, because that person takes a risk of 1 in 1,000 of dying for considerably less all the time, whether that person knows it or not, but they actually engage in activities. But let's take that figure. If I then say, okay, 1 risk in 500, it may be half that, but probably isn't. But if I say 1 risk in 2 of dying and offer that person 500 times what they had said, 1 risk in 1,000, the person says, you're crazy. And if I say, I now know what your life is worth because you've told me that, and I want your heart because I need it for a transplant, or your brain because I need it for a transplant, here is the money, now shut up and give it to me, the person throws me out the window, and that's justifiable homicide. So I don't think that the price of life is establishable independently from the risk, with an odd quirk, because we all die. You're all young, so you don't know that. But at my age, you have to know that. So that it's an odd quirk. We know, and we are going to die, and yet the premium, the life value, increases with the likelihood that we're going to lose it until you get to the point of certainty that you're going to lose it. And then quite strange things happen. If you listen to the phone calls, tragic phone calls of people at 9/11 in the building, you come to terms with it. So I'm not sure I ever am satisfied with a figure for life that is put in. I understand why people try to do it, but I'm not sure that I'm satisfied with it. I'm not, as I say, I don't know quite where that leaves me, but I do know that just doing a statistical thing of that sort leaves me a little bit uncomfortable as to what one then ought to do, even from a deterrence point of view. And, we tell juries, we don't let juries say, what would you be paid actually to go through that? That is the one-on-one. That's too much. But we usually don't tell juries the statistical data of 1 in 1,000 either. So I don't know what we're doing.
Well, thanks for returning to my favorite topic. And generally, the value of statistical life numbers are only pertinent for very small probabilities. And that's typically what you're facing when you buy a product. So even if you happen to buy a Toyota with unintended acceleration problems, there's not a 1 chance in 2 or 1 chance in 1,000 you'll die or kill somebody. Usually it's a small probability. So to the extent that we're playing in the realm of small probabilities, we're okay. The numbers change enormously with the magnitude of the risk. And there's also a big difference in the spread between whether you're being paid to incur the risk as opposed to paying other people to get out of the risk. So if you were told that you face a prospect of certain death, how much can you come up with? To avoid that risk, well, you come up with all the present and future value of your resources. You'd borrow money from friends, but it would not be an infinite amount of money. However, if somebody said, how much do I have to pay you so that you're indifferent between getting this pile of money here and facing certain immediate death, there's not enough money you could put on the table that would make me think this is a good deal. So really, the probabilities are really critical to this. And once we get into particularly a medical decision-making context where the probabilities get big, then I think then you start to run into trouble with applying this. So I'm going to stick to the small probabilities.
Okay. Thank you very much for the presentation. I just want to ask Alain to come here. So this has been a very interesting workshop, and we learned very much. We want to go on this, so the project will be to have a special issue of the journal Law and Contemporary Problems in a year or so. We hope it to be much faster than what happened to your some thought paper that require. So hopefully next year this will be published. Thank you to everybody. Thank you for the host. And of course there are still the other presentations. Do you have something to say, Alain?
No, it's all right. Just wanted also to thank you and congratulate the presenters for the papers.
All right, thank you all for your wonderful presentations. We still have 2 more panels to go, and we are slightly behind schedule. So let's have now a 20-minute break, coffee break. Coffee is ready. Then let's split into panels. And we'll meet here back on this ground floor at 6:15 for few concluding remarks and farewell.
Great. Sure. Thanks for throwing me a softball.